here is the message of relief. The ISDS is not needed. It's not needed. Why? Well, because the American and the European legal systems are the most developed legal systems in the world. Nobody has challenged that fact. The pathetic examples given by the Commission of the 2 or 3 companies that in the United States may have suffered some damage because of American problems, they may be real problems, but they are marginal problems. They are not systemic problems. Even the European Commission hasn't suggested that the American legal system sucks. So it's not needed. It would be unjust to treat foreign investors, American investors. There is a history of investment disputes. There have been about 250 solved cases in this system. By far the largest number of these cases have been raised by investors who are part of the Fortune 500 club. So these are really powerful companies. Think of Philip Morris. You all know the Philip Morris case. Think of Vattenfall. Powerful companies. Why would they don't need it? But they want it, of course. Anyway, so I want to make the point that I'm against it, but I'm not the only postmodern weirdo who's against it. Other people are as well. European Council for Foreign Relations, Atlantic Council, the former president of the World Bank, etc. 6 reasons why this thing is needed. It's not needed because it strengthens the hand of the most important global actors. Every lawyer, every American lawyer, that is to say, knows that arbitration is not important because of the cases, because of the awards, the decisions that are being taken, because of the tremendous wisdom of those cases. No. Arbitration is important because the existence of the system strengthens the hands of the parties in negotiation. Then the parties who can say, if you don't agree with me, see you in court. So if you look at only those 250 cases, you look at the top of the iceberg, but everything is below sea level. Mixing metaphors. So everything is about a change in the negotiation, in the bargaining system between states and great companies. Let me give you an example. So I realize I have to be very quick. So imagine this situation. A foreign investor in the health insurance business, for example, in the private health insurance business, has a problem with new health insurance legislation being proposed. And that company is covered by the coming treaty, and they go to the Finnish Health Insurance Authority, which is preparing the new legislation, saying, please don't make that legislation in this way, rather make it in that way. So here there is the Finnish or European bureaucrat faced by a claim by an American investor in an insurance scheme, and she would have to think the following. Well, now if I don't do this, the company will make a claim against Finland. The average cost of claims, just the costs of the trial, are from 8 to 30 million US. This will be taken away from the health budget. Can I go? Should I go? This is independently of what the substantive decision of the arbitral tribunal would be. Now, then the bureaucrat would have to look at previous cases. Well, how is the tribunal, how should I expect it to decide? Well, when that person looks at the jurisprudence, the person will see that decisions have gone in all conceivable directions. There is no predictability whatsoever. Of course there isn't, because the tribunals are composed each time separately. So it's always 3 different individuals. And they, of course, represent different kinds of ideas, interests, etc. So with the same facts, we have different decisions. So you don't know. There it is. The American company is saying, well, if you don't do this little change in your proposed bill, then see you in court. And with the amount of money that the Finnish health insurance nowadays, Finnish health administration nowadays receives, are you going to risk that? At least $8 to $30 million, maybe much, much more. I leave that aside. So that's the problem. The bargaining power situation changes. I'll just run through this rapidly. The whole arbitration thing is technically poor. I already said decisions go in all conceivable directions. There's no predictability. There are many infamous cases. I don't have the time or the interest to go through them. You've seen or you've heard a lot about them. Here are some. The investor-state dispute settlement system threatens debt rescheduling. That's because what is happening now, what we've seen with the Argentinian financial crisis, hedge funds buy junk bonds, and they refuse to participate in debt rescheduling schemes such as was just concluded between the European Union and Greece, and they demand the full amount of the debt outside the debt rescheduling scheme. What happened in regard to the Argentinian debts was that the whole plan, to which over 90% of Argentina's creditors had agreed to, well, collapsed because a small number of hedge funds declared they would not participate in the rescheduling. Instead, they wanted to have a full amount of the claim. The American judge who decided on that claim requires that Argentina doesn't pay the rescheduled amount of the debts, because this would mean that a part of the creditors would be treated unequally in regard to the hedge funds creditors. There are presently already cases against Greece on this basis. The ISDS probably breaches against European Union law. Just a couple of months ago, the European Court of Justice in Luxembourg decided that the European Union will not become a party to the European Convention on Human Rights under present conditions, because it's inconceivable that the European Court of Human Rights in Strasbourg would be entitled to take decisions on the basis of the content of European Union law. Now, the arbitral tribunals would automatically be called upon to interpret European Union law. So under these decisions, the advisory opinions of the European Court of Justice, the whole damn project is illegal. It also turns the European Union into a sitting duck. I don't have the time to tell you the stories about what happened with Canada under the NAFTA agreement, the North Atlantic Free Trade Agreement. There have been 35 cases which have hit at every conceivable part of Canadian legislation. Why would it be differently here? No reason to think it would. One of the scariest phenomena in the international investment field is the emergence of third-party financing companies. Companies that finance the raising of claims against states. Here are two of those companies. Their annual reports from the year 2000 tell us that they received huge profits from the cases that they had been financing. So I just summarize here. In the investor-state arbitration sucks. It presents a serious and credible threat to the democratic decision-making in European states. It opens the opportunity for some of the most powerful global private actors to challenge systematically new legislation in Europe in all conceivable fields of European sovereignty. I need to end, and I will end with this. We don't have the treaty text in front of us. It would be nonsensical to say what is against or in favor of a treaty we don't have. I put forward certain doubts about the proposed benefits of the treaty. I have suggested that taking a position on the treaty is a political and not a technical issue. And I have presented my view as an expert in public international law as to the effects of one important part of that treaty. It is possible, as Aleksi said, that this will be amended. I don't think it will be. I don't think it's a coincidence that the large companies are pushing this forward in order to take cases and laws regarding their operation away from the domestic context to be decided in the global context in which they are the masters of the universe. Thank you.